Hello everyone and welcome back to the channel. A few months ago, Trump's DOJ made the announcement that they were creating a path to rights restoration, though that should be an oxymoron, when it comes to gun rights. Technically, this path was already supposed to exist through Section 925C of the Gun Control Act and had been delegated to the ATF, but the funding to do so had been blocked since 1992. According to the DOJ in this document, the ATF didn't have proper criteria and made a bunch of bad decisions that jeopardized public safety, took too much time, and spent too much money doing it. The document gives a few examples of this, alleging that the ATF gave rights back to felons convicted for sexual assault, armed robbery, and homicide from a random sample of 100 that the ATF had apparently given relief to. The DOJ claims that people were somehow able to lie on their applications and were given relief even with recent convictions. Given that the old process included a criminal background check, I'm not sure how exactly that happened, but that was Congress's reason for cutting the funding. Fast forward to earlier this year, the Trump administration told us that this process would be for nonviolent felons and that it would be handled by the DOJ, but didn't tell us much more. Ever since, folks have been asking me for more info on that, how they apply, who they apply to, etc., and I finally have that information to give you thanks to a proposed rule dropped by the DOJ on Friday. Now, I did hope to get you guys this sooner than today, but wouldn't you know it, a funny thing, it turns out that a migraine doesn't really mix with legal mumbo-jumbo. Who'd have thought? Now, this is just the unofficial version, as it is only a proposal as per the little note at the top of the 48-page document, so this might not be the final process. But this spells out what the DOJ is thinking in terms of the who, the how, and the when. But first, this video is brought to you with the help of the Attorneys on Retainer program from the Attorneys for Freedom, and the only law firm that exclusively works on self-defense cases. If you ever find yourself in a self-defense situation, it is definitely something that you do not want to have to face alone. The folks in the Attorneys on Retainer program are, true to their title, actual attorneys, whose entire job it is to give you legal advice and represent you if you use your gun in self-defense. They're not an insurance company, which means that when you call their hotline, you talk to an actual lawyer and not an insurance adjuster. It also means that they don't have the same fine print, so their only requirements are that the incident happened after you signed up and that you reasonably acted within good faith. Doesn't even matter if you were a prohibited person, a felon in possession. They cover it all. They cover everything from felonies to misdemeanors, appeals, and even bail bonds. And this year, they have added tons more features, including red flag hits, which, with the typical lack of due process on them, is a whole different kind of self-defense. So switch over from your existing self-defense coverage by using my link down in the description, and you can use code LibertyDoll to get $50 off your individual sign-up fee. Now for the information that you came here for. As an aside, remember in discussing this proposed rule that the DOJ refers to whatever someone's reason for being a prohibited person is as a disability. That'll come up a few times. This rule also starts off with a reminder that while Heller and Bruen protect the right to keep and bear arms, Rahimi preserves the government's ability to disarm anyone it thinks is violent or poses any kind of danger. It also addresses the split in the courts on individual cases as to whether a blanket ban on all felons is constitutional or not, like in the case that I spoke on a few weeks ago about the woman who wrote a bad check almost 20 years ago and went on to be a model citizen. This document claims that their criteria will put all of those lawsuits to rest. Only time will tell there. So it starts with a list of those who will be considered ineligible for rights restoration outside of extraordinary circumstances. Persons currently subject to the prohibitions in Section 922G2, fugitives from justice, G3, unlawful users of controlled substances, and G8, those subject to domestic violence restraining orders, would presumptively be denied relief because, having an adjudicated status that indicates a lack of respect for the law and potential dangerousness, they are unlikely to meet the statutory criteria. Moreover, such persons can ordinarily take themselves out of the prohibited category by discontinuing their unlawful conduct or, in the case of Section 922G8, seeking a modification or early termination of the protective order. Individuals subject to the prohibition in 922G5, unlawfully present aliens or certain aliens admitted on non-immigrant visas, would also be presumptively disqualified because unlawful aliens are not part of the people to whom the protections of the Second Amendment extend. So that is the framework here that they're using. The rule does give a list of violent crimes that are disqualifying, saying people convicted of them have a higher recidivism rate, meaning they're more likely to reoffend with another violent crime, and largely says that it pulls this list from the Federal Firearms Act and the U.S. Sentencing Guidelines. It also blocks things like stalking and all felony sex offenses, stating that they are 3 times more likely to be arrested for the same crime within 9 years of release. Those barred crimes minus extraordinary circumstances are 1. The death of another person, sexual abuse or sexual assault, human trafficking, kidnapping. 2. Intimate partner and domestic violence, animal abuse, burglary, robbery, extortion, carjacking, arson, racketeering, if at least one of the predicate racketeering acts is violent, or gang-related offenses. Remember, all of these at the felony level. 3. Assault or battery. 4. Threats of violence. 5. Stalking. 6. Escape or rescue of a fugitive. 7. Terrorism. Or 8. Witness tampering. Section 2. Has been convicted under state or federal law of any felony offense involving conduct prohibited under 18 U.S. Code 922G and a whole string of other letters and numbers, which is the stuff mentioned earlier: fugitive from justice, drug addicts, anyone adjudicated mentally defective, and illegal aliens, anyone with a felony offense related to a dishonorable discharge from the military, domestic violence restraining orders, anyone dealing in stolen guns or guns with the serials removed or likely to sell guns for terrorism and other crimes, etc. 3. Has been convicted under state or federal law of any felony offense involving the manufacture, possession, transfer, or use of explosives. 4. Has been convicted under state or federal law of any other felony offense where the defendant committed or threatened acts of violence or used, brandished, or discharged a firearm or explosive in the course of committing that offense. 5. Has been convicted under state or federal law of attempting, soliciting, or conspiring to commit or aiding or abetting the commission of any of the offenses listed in paragraphs A1 through A4 of this section. So basically all the ones I just said. 6. Is currently required to register under the Sex Offender Registration and Notification Act or comparable sex offender registration statute based on an offense that disqualified that person from possessing a firearm under the Gun Control Act. 7. Has within the last 10 years been convicted of or served any part of a sentence, including probation, parole, supervised release, or other supervision, for an offense under state or federal law punishable by imprisonment for a term exceeding 1 year that prohibits the manufacture, import, export, distribution, or dispensing of a controlled substance, or the possession of a controlled substance with intent to manufacture, import, export, distribute, or dispense, or has, within the last 10 years, been convicted of or served any part of a sentence, again including probation, parole, supervised release, or other supervision, for attempting, soliciting, or conspiring to commit, or aiding or abetting the commission of an offense listed in this paragraph A7. 8. 1. Has within the last 10 years been convicted of or served any part of a sentence, again including probation, parole, supervised release, or other supervision, for a misdemeanor crime of domestic violence, or 2. At any time within the 10 years following a conviction for a misdemeanor crime of domestic violence has been A. Subject to any of the disabilities set forth in 18 U.S. Code 922G, which are all the charges I mentioned earlier under number 2, or B. Arrested for an offense punishable by imprisonment for a term exceeding 1 year, a misdemeanor crime of domestic violence, or any offense where the defendant was alleged to have committed or threatened to commit acts of violence or used, brandished, or discharged a firearm or explosive in the course of committing that offense or attempts thereof, barring evidence from the applicant of a judicial determination that no misconduct occurred. 9. Has within the last 5 years been convicted of or served any part of a sentence, including probation, parole, supervised release, or other supervision, for any other offense under state or federal law punishable by an imprisonment for a term exceeding 1 year. 10. Is currently serving a sentence of imprisonment. So, surprise, you cannot apply from jail. 11. Is currently on any form of supervision as part of a criminal sentence, again, such as probation, parole, or other supervision. 12. Is currently a drug addict, fugitive of justice, or under a domestic violence restraining order. Or 13, has at any time had an application for relief under this section denied based on a disqualification under paragraphs A1 through A5 of the section, or has, within the previous 5 years, had an application for relief under the section denied for any other reason. So basically, as you can gather from that mouthful, there are a lot of disqualifications unless you can prove extraordinary circumstances that make an individual not dangerous. It also says that this only applies to federal charges. It does not grant relief from state laws that bar certain people from gun ownership. And of course, if you are granted relief and then go back to crime, you can and will lose your rights again. So preferably, don't do that. But anyone with a non-violent or less serious felony, not otherwise blocked by state law, and 5 to 10 years of a clean record, depending on the individual charge, is free to apply. Now note, some of these listed charges are also a little tricky. The DOJ gives the example of drug dealers saying, yeah, we said that they can apply after 10 clean years, starting once their parole is complete, but serious drug dealers' sentences are typically so long anyway that they're unlikely to ever be able to apply or will be old by the time they do. That is by design. It also makes a note that special consideration will be given to misdemeanor domestic violence charges that did not involve a firearm or potentially lethal violence. It also says that the goal is to avoid the categorical approach, meaning in each application, all the facts leading up to the crime and conviction are supposed to be considered. For example, whether someone also has documented substance or mental health issues, had multiple arrests even if they did not result in convictions, or had a perfectly clean record prior. The proposal says that the DOJ will glean this information from direct cooperation with the chief law enforcement officer in the applicant's locality. Now, of course, there is always question as to what they will consider a disqualifying mental health or medical issue, but I suppose at this point, if you've already lost your rights due to a felony conviction and are applying to the Department of Justice to investigate it and decide whether or not to give you your rights back, you're already at a point where there's not much to lose as far as them combing through your mental health or medical records. Is it my favorite thing? Absolutely not, but I would hope that maybe it would be limited to inpatient mental health treatment or times where some kind of dangerousness to the self or others was proved. You know, and that goes back to the Tarasoff laws and duty to warn that I talk about like all the time, every time a red flag thing comes up in the news. As for the actual application process itself, the DOJ estimates a $20 fee to fund the program, which I found surprisingly low, and they say that it might be adjusted over time. It's not terrible. The application will include sending in whatever forms the DOJ comes up with, either online or by mail, along with all relevant court documents, medical records, military records, as well as an authorization that would allow the DOJ to do their own investigation into the person's employment history, medical history, military service, and criminal record. They'll also have to have 2 FBI-approved fingerprint cards, a criminal record check from every state where the person has resided since turning 18, and an affidavit from 3 non-relative character references attesting, under penalty of perjury, that the applicant does not engage in behavior that would make them legally prohibited or otherwise unfit to possess firearms. So there are a lot of checks and balances here and protective measures. Now, I'm of the opinion that if you are someone that has done your time and you have been deemed safe enough to return to society, you should also have all of your rights back. If you are so dangerous that you cannot have your rights, then you are too dangerous to be in society. Obviously, that is not the world that we live in, and the DOJ is clearly trying to placate both sides in some of their rules here. Now, the DOJ estimates that roughly 1 million people will apply within the first year, giving them a budget of $20 million to work with. Half of that is expected to go towards hiring 50 new full-time employees to handle the applications. Folks will have 90 days for the public comment on this rule, as per usual. There are still some big questions, like how quickly they can get this online portal up and running, what the application forms will look like, those are apparently still in process, how long the process will take, and other things related to the DOJ's vague statement admitting that this is a new and untested application process. We also don't know how much of this will be dependent on new funding from Congress. In a June budget request, the DOJ asked for nearly $500,000 for this program, but the current appropriation bills going through Congress don't have any funding for the program at all. The version in the Senate actually still contains language preventing the ATF from using funding for this program that they are no longer assigned to do. So again, this is just the current proposal. It is not the final rule. It is still subject to change. You guys have 90 days to take a look at it, leave your comments on it, and I will link the full proposal down in the description. That is it for this video, guys. Hopefully this information is as clear as I could make it for all the legal speak. You guys know the drill. For all of the algorithm things, please do them. And as always, thanks for tuning in. Stay safe out there and happy shooting.